Hello and welcome to Savvy Seniors. I'm Mary Dilley.
And I'm Jeanette Bach.
And today we have Sharon Davis with us, and Sharon is an estate lawyer. So she's going to answer all of our questions. First of all, what is estate planning and what's involved?
You know, Mary, that's a really good question because there's a lot of mystery surrounding estate planning, and people think of death and dying and they're very sort of upset about having to go through the process. And really, I think that estate planning is as simple as an extension of looking after people in your lifetime, right? We all have jobs, we all have loved ones, we all have family, and we look after them throughout our lifetime. And so really it's the organization and looking at your affairs to make sure they're in order so that everything goes smoothly and how it should after your death.
Okay. So what are some of the areas that you consider within an estate plan? Because I think that is something that most people don't really understand.
It's a very technical area of law, actually, and I think there are a lot of misconceptions about how things work. You know, with respect to a basic plan, everyone knows what a will is, right? You know, you put down who's going to look after your estate after you die, your executor, and who's going to get what's left over after all the bills are paid. But ultimately, there's more to it than that, right? There are more ways, I think, to leave money to people than people realize. So when you have a will, it governs everything in your name alone at the time of your death. And so being very specific about, you know, to which family members or loved ones you want to leave your estate, you need to be very clear. There are a couple of different ways you can do a will in Ontario. Most relevant, perhaps, maybe to seniors would be the regular formal will you would do in a lawyer's office. It needs to be witnessed by two people. It needs to be properly executed. You can also do a holograph will, which sometimes people don't understand as a possibility, especially, you know, with seniors who may not be able to get out. You can do a holograph will that's completely in your own handwriting, and that's a very valid will under our Succession Law Reform Act. The key is you have to make sure that it indicates it's a testamentary document, that you want to leave things to people, and it's your last wishes, and you have to make sure that you sign it at the end and that it's entirely in your own handwriting. So that's also a very valid way to do your will.
Do you have to have a witness for that?
You don't need any witnesses, and you know, something is always better than nothing. I know people have heard a lot about will kits. There are a lot of issues that you can get into with respect to will kits and even holograph wills, because the understanding of how the law works is not there for your average person. So when you write things down, for example, it could be ambiguous. And so if the executor doesn't know who you mean when you state a certain name, or you get the spelling wrong or what have you, then it's difficult to administer the will, so you have trouble on the other end.
I'm sure it could be challenged also, because say in an example, when you go into a lawyer's office and they see that you're of sound mind, what's your name, what day is it, you know, they can tell that you know what you're doing, and then 8 years later at your kitchen table you do your own little will, and maybe, you know, things are going to the pool boy. Who knows? I don't know. I don't have.
If you're lucky.
I know. I was just going to say I don't have a pool boy, but if I did, I'd leave everything to him. But so I can see that maybe that would be challenged more than a will done in a lawyer's office?
Well, you're exactly right, because there are three ways to challenge a will. And one is that it doesn't meet the formal requirements. Two is that you've had someone unduly influence the testator. It's a very difficult thing to prove undue influence. There needs to be independent, you know, evidence to show that someone has done a will that really was not their true wishes, that they were forced. And there's a great degree of you know, burden of proof to prove that sort of thing. And of the third, of course, which is related to undue influence, is capacity. Because as you say, you're very right when you say it's a lawyer's job to make sure that the wills that are being drafted are being done by people who understand the nature and consequences of the documents they're doing. So as someone let's say someone has dementia, it does not mean that they can't do a will, right? Capacity is a question of fact, and it varies. You could be capable in the morning and not capable in the afternoon. And who knows, when you're sitting at your kitchen table doing your holograph, which one of those you were, capable or incapable. And as that changes, the undue influence obviously changes. So when testamentary capacity goes down, undue influence ability goes up. And so there are a lot of factors that go into a will challenge. And as you know, as they say, wherever there's a will, there's a relative, and someone to complain about something at some point in time. So when I do will planning, I certainly pry into people's lives, and I don't have to watch soap operas. I get all of the dirt on everyone's family, and I have to, because if I don't, I can't make the appropriate plan. There are different kinds of documents you can do. There are different ways that you can protect against a will challenge. You can produce the evidence that's required. I often suggest that people, if they're cutting someone out, for example, right? Why are you doing that? I had a case end once because there was a handwritten note explaining why the person was excluded from the will. And when you see that in the testator's own handwriting to a family member or a loved one, this is why I did it. You know, it's very difficult, I think, to, on a moral basis, let alone a legal basis, to say, okay, you know, there was no reason for this to happen.
Now, everyone talks about probate. Is there a quick and easy way to talk about probate?
Oh, the P word. Yes, everybody wants to avoid that. You know, probate is not a legal requirement. It is a practical requirement. So probate is essentially where you take the will and you bring it to court, and there's a public process. So once you file your will with the court, your neighbor can go look at it. And there's an opportunity to complain about it. You file a notice of objection with the courthouse. It's a paragraph document, and you're off to the races on a will challenge. And when you apply for probate, for the privilege, you have to pay 1.5% of the total value of a person's estate. So there's a tax there, right? It's a state administration tax, appropriately acronymed EAT. So it eats into whatever you're going to leave to your, your beneficiaries. So there are lots of ways that you can avoid that. And if you do your planning properly, you wouldn't necessarily need probate. You can understand how a bank, for example, wouldn't want to take a will and go, okay, Mr. Smith, it looks like you are the executor of this will done in 1984. I'll give you the $1 million that the deceased had, because if someone comes along with a will done in 1985 or later, they've given the money to the wrong person. So that's why financial institutions and land registry offices will not hand property on to, to executors unless they know that they will be absolved from liability, and that's what probate gives you.
Okay, interesting. This boggles my mind. Everybody has to pay taxes, and everybody is going to die. Sorry about that. Sorry if I ruined your day. However, why? Spoiler alert. Why is it that people don't do wills and powers of attorney? Why?
Well, there are a few theories on that, I think. Firstly, I've heard a lot of colleagues talk about superstition. You know, people feel that if they're going to do a will, they're going to die the next day. And I have to say, I've never had that happen. I've never had not that it couldn't. Anything can happen anytime. But it more often than not gives you peace of mind, and you feel better as opposed to feeling worse. Because I think you feel like contemplating your own mortality and your death is sad, and something horrible could happen to you.